so he doesn't have to pay U.S. taxes. And those are frivolous arguments. So the default is, yeah, he owes those taxes. But somebody like me just logically comes in and says, I'm not making any of those arguments. I'm just simply, there's no code section. Show me the code section, produce it. Well, they don't. All right, so we go through that process. My appeal gets denied. Then we go down further down the road, and the last minute before the IRS can file suit on the 10-year statute of limitation that exists, they file suit and to foreclose on my house. They want to take my house. Now, what they consider an original debt of somewhere around 40,000, they've run up to 145,000 with interest and penalties. Now, in this process, they file suit to do this. You go back and forth, and you got your discovery stuff going on. I file for interrogatories, and I file for documents that would demonstrate the code section that imposed a tax on me, or the documents for the documents, actual assessment documents that I've been asking for years. So I'm asking for the code section that imposes the tax. I'm asking for the documents of actual assessment and what they do with a form they call a substitute for return. Well, my answers come back with a bunch of forms that they list, and they don't answer the question directly. Their question is evasive, and their answer is evasive, and as it had been. And on one of them, the answer was so evasive that the judge actually made them go and answer it more completely, if you will. And the question is, when I asked what code section imposed a tax on me, their answer was, the code is public record. Benoit can go find that information for himself. And the judge wasn't going to accept that extraneous of a tyranny, or extensive tyranny. So he said, no, you need to tell him, he's been trying to get that answer, you need to tell him the answer to that. So they come back, and they were still evasive. They don't say that here's the code sections that impose a tax on Mr. Benoit. What they do is they say, here are, and they gave 9 code sections that relate to this matter. They still did not answer the question. And then in the production of documents that I asked for, when I asked for copies of the assessment, or I asked for any documentation that listed a code section that made me liable for the tax, they would respond that Benoit has been notified of his tax liability. And so they don't, they're evasive answers, and they don't have to answer it. So here we're going at this point in time, and there's certainly, I got a lot of disputes, and I got a lot of disputes about, they have penalties that they're adding on in this process, and those penalties include, where willful, where you're willfully negligent. On all those penalties, you have to be willfully negligent. And so, in the definition of willfully negligent relates to, you have to do the thing, and then you don't do it, and it's willful. You just don't do it. You're negligent, and you're willful about it. And that's the only time those penalties would apply. Okay, so there's many numerous issues. No assessments. No, they can't produce a substitute for return. They have no return on file. And they won't produce the code section. And there's the forms that they're using were produced in 2007 and 2009. It's supposed to be a tax from 1995 and 96. These forms, there are 2 competing forms. They're different. They're not the same. One has a tax imposed or penalty imposed that's actually duplicative from an earlier penalty that was imposed, and far exceeds their maximum penalty in that process. So these forms that the government allows, or the judicial department allows for the IRS to use and get away with giving something called a summary judgment. Summary judgment is a process where you don't get your trial, and summary judgment is supposed to be used when the facts are not in dispute and that it's just a matter of law. And of course, there's a lot of facts in dispute on this case, many facts in dispute. But then what does the judge do? He turns around and he says, although Mr. Benoit says the facts are in dispute, we find that he has a technical disagreement with the facts and that actually the facts are not in dispute. So they're ready to go, here you go, bam, take your house away on the summary judgment process. Now, another cute trick in this process is the state of California. They had claimed that I owed them some money too. And so the IRS, when they're suing me, they have to name the state of California as the defendant. Now, you would think there'd be another plaintiff trying to get my money, but no, they're named as a defendant. So in my motion for summary judgment, I called out the fact that the state of California never actually assessed the taxes and that the statute of limitation had run on them anyways. If there was a liability, their statute of limitation to collect was long past by 6 years. Okay, so there's no way they could actually get the debt. So I wanted them dismissed and their debt expunged as their alleged debt expunged as being owed. Well, judge doesn't even look at that whatsoever, doesn't make any ruling or any statement on that. Now, the state of California did not deny that they never assessed the taxes. They made some squirrely argument that the district court didn't have jurisdiction. And that squirrely argument had some basis as if there was a remedy through the state, then somehow that the federal court did not have jurisdiction. So in my reply, I'm saying, well, if they don't have jurisdiction, then why is the state even here if they don't have jurisdiction? So there's no way the state could collect that money in a state court. Well, with the court not addressing it, and they grant the government, the IRS, their summary judgment motion, denying me a trial, denying it all these things, the $144K. Maybe if they could prove up that I actually owed the original amount, that'd be one thing. And then why didn't they prove it up from the beginning? Why didn't they show a code section? Why didn't they show the assessments when I asked for them? I'm saying, this is not a debt unless you can show me the code section and give me an assessment. And I think we ought to be entitled to that by law. Well, they certainly don't want that to sit in front of a jury, all of this information that comes out. The government can't produce the code section and imposes a tax on the American people. All they can produce is some nebulous thing that says a tax is hereby imposed on the taxable income. What's that mean? And what's taxable income? And income is not defined in the Internal Revenue Code either. Okay, where do you have to find a definition of that? Well, it's a constitutional term. So what did it mean back in 1913 when the 16th Amendment was passed? And what did the court say it meant? And that's the definition that they have to use. So what am I doing now? I'm in the Ninth Circuit Court of Appeals. And under the Due Process Clause and the due process protections that our founding fathers put in the Constitution, they put it in there because they knew how government could become tyrannical and how government could violate people's rights. They put in there a couple of places that were entitled to due process of law. Now, I looked around to study, to find out exactly what does due process of law mean. And actually that's a very tough concept. And I guess it's a concept that people have been kind of pondering for maybe decades and maybe centuries. But reading in Black's Law Dictionary, going back to I think it was 1891, the first Black's Law Dictionary, it said whatever confusion there might be about due process, when any fact be positively assumed, I'm paraphrasing, against a party, that certainly is not due process. So there's lots of facts that have been positively assumed against me, and it certainly is not due process. And so I'm not going over each and every point of argument there, but I want my trial by jury, the Seventh Amendment. But if the judicial system is allowed to just say, oh, we grant a summary judgment for the government, regardless of how egregious their actions might be, and they can just imagine and dream up out of thin air that you owe a certain amount of money, and you say no, and they can turn around and say, we got this form, and the courts say, well, we got these forms here, so we're going to give the government summary judgment, and boom, there you're gone. Is it? Well, to me, it's too late. That's the way. We can't even fight these tyrants in a court of law anymore. Sound reminiscent of the founding fathers? Well, if enough people stood up and said, hey, look, show me the law that imposes the tax on me. And again, if you're going to study this stuff, take the time to study it right. If you want to read these guys that go down these different branches, just keep in mind that you don't want to argue. I wouldn't ever want to argue, try to prove a negative. Let the government prove it. They can't produce the code section that imposes a tax on me. They won't answer the question, is it a direct tax or an indirect tax? And then there's so many other things that come up, as like, how can they hit your bank accounts? How can they hit your employer? And you dispute the debt when the Seventh Amendment gives you a right, guarantees you a right of trial by jury, and then the due process rights. This is just an anathema to freedom. Just because we have more affluence in this country, we're very close to being the same as what happened in Libya and the repression of all these other regimes. We just happen to be a little higher up in the food chain right now, but we're coming down that ladder. No telling where we'll end up until we once again learn to respect the Declaration of Independence, that we all have unalienable rights, that life, liberty, and the pursuit of happiness are among those rights, and that the government can enslave us to take the fruits of our labor to give somebody else. So that's all for now.